everyone. Good afternoon. Thank you for joining us in today's webinar. Myself, Vishaka Khambati, Faculty of Biomedical Engineering Department of PITTS, Parul University. Today we are presenting a webinar on patenting of innovations, which is presented by Dr. Adinath Damle. Currently, he is working as an associate professor of Mechanical Engineering Department at Sanjeevani College of Engineering, Kopargaon at Ahmednagar. Sir is also government certified patent agent at Pearl IP Solutions. Sir has filed more than 20 patents for different clients in the different domains of the engineering field like chemical engineering, biomedical, then biotechnology, pharmacy, etc. Sir has completed his basic educations from Government Polytechnic, Ahmednagar, and completed his master degree from MS University, Baroda, and PhD from University of Pune. Sir has total 17 years of academic experience, 2 years of industrial experience, and 4 years of research experience. Sir has published more than 18 papers in national and international journal and conferences. So it's all about introduction of Dr. Adinath sir. So without taking too much time, I will hand over today's session to Dr. Adinath sir. Sir, please continue.
Okay, thank you, ma'am. Before starting, let me know, am I completely audible as well as my screen is visible?
Yes, sir.
Okay, thank you. Thank you, Vishaka ma'am, for introducing me. Uh, this is again, you can say it's a new part for us, other than our day-to-day technical fields what we are going through. But in the changing scenario, this is a required one. We means I'm talking about we all Indians. We all Indians are having much more abilities with us, but some minor things we don't know why we are missing so much good possibilities of new patents and new some IPRs. So some of the aspects we'll try to understand today. We have only 1 hour with us, so we'll try to take more and more benefit of this 1 hour for taking the IP related things, right? So starting with these are some major points which I will discuss. We'll try to understand IPR, then types of IPRs, then Indian patent system, how it has developed in India. That will be the brief discussion.
Hello, sir.
Yes, ma'am.
Hello.
Yes, ma'am.
Sir, sorry to interrupt you, but sir, you are not properly audible.
Yes, wait a minute, let me check.
Sir, can you speak a little bit louder?
Okay, you mean to say that my voice is not coming properly?
No, sir, not audible properly.
Wait a minute, check. Let me rejoin ma'am again. So if
Okay, sir.
there is an issue with my mic, then I'll check it. Hello, ma'am. Now am I audible?
Yes, sir, completely audible.
Okay, thank you, ma'am. Now coming to again the main slide. This will be our topic for today's discussion. Now, before starting, let me put the major highlights today's discussion. We'll talk about IPRs, then their types, brief about Indian patent system. Then one of the major discussion part will be what are the inventions which are not coming in a category of patentability. So non-patentable inventions we'll discuss. Then what things are there which make the invention patentable? That will be the part of discussion for patentability criteria and patent filing procedure in India. will be the one of the part for discussion with patent filing documents and their fees. And finally, we'll discuss about some tips for making the patent possibility more and more effective. Right. So this will be something broad discussion.
Sir, kindly share your screen.
Okay. Sorry. This I forgot. Yes, I have rejoined. Na? Ma'am, is it visible now?
Yes, sir.
Okay, thank you, ma'am. Sorry for again interruption. So I was talking about something, the contents of today's session: IPR, types of IPR, Indian patent system, then non-patentable inventions, patentability criteria, then patent filing procedure, documents required with fees, and finally some important tips about making the inventions patentable. Right. So this will be some of the contents for today's discussion. Now to start with, very basic questions I'm just asking, or when we'll just take that, should we go for intellectual property protection, or do we need to protect? So if you try to answer these questions in both way, then what we get, if you say that no, we don't want to protect any IP, then how it will benefit? It will benefit that as it is free, because not registered, so it will be free to everyone. No need to pay any royalty. Nothing will happen. Nothing will happen, and everyone will get free everything of the patented part. Likewise, if we say opposite, what will happen? If we go for opposite, that is creating the registered or protected IPs, then it will help to create more and more ideas, more and more new developments for the creators. It means creators will put more efforts to develop new and new idea. Investors will come to invest because they are sure that later, once they are getting ideas getting protected, they will get returns. Example, if you take in present scenario, all we are going through this online webinar because due to pandemic, and how this pandemic is being tackled now by using the vaccinations. So all the vaccinations which are being developed in the world, they are first protected, and then they are coming to the market for testing, and I mean that all use purpose, right? So if their idea or if their invention is not protected, then they might not have done this because it needs very heavy investments, time, and intellectuals for that. So protecting IP is taken a, you can say, positive way for benefiting the peoples, because it will encourage to develop more and more inventions and innovations, right? So in general, when we say that IP, of course, it's a product of mind or intellect. And when we are talking about IPR, then R gives a right for protecting the intellectual property. And this IPR is a right held by a person over a creation of mind. This right is given for creation of mind, and for a particular period of time in a given jurisdiction. It means whenever we are getting any IPR, that IPR, of course, is the output of some creative mind, and that IPR is given for some certain period and in a given jurisdiction. So when we say we have one Indian patent, then Indian patent is applicable in a jurisdiction of India. If anybody copies it in outside the world, and if it is not national patent later on, then we are helpless to restrict him or her, that who is infringing the patent, right? So it's a jurisdiction based given for the specific type. Then IP is taken as like our conventional property. Intellectual property is taken as conventional property, in which the owners of the IP has given exclusive rights, like variety of intangible assets, often in a limited period of time. What do we say? That whatever we are having conventionally rights about the conventional properties like our land, home, car, likewise. So for that, same rights are given for the IP also. But one interesting fact about IP is that when our constitution was developed initially after independence, at that time there was no word about IP in the constitution. Because whenever we talk in our day-to-day life, every time we say that this is a democratic country and what is written in constitution according that it is happening, and many times people say that this is the constitution and this is the law. Interestingly, there is nothing about IP, but there is something is mentioned about property. Property is mentioned, and IP, though it is taken later as a part of development, because main patenting systems in India after independence has started from the 1970 broadly. That is India based completely, right? So after that, property concept is taken. Conventional properties and IP property are taken exactly same, and whatever rights conventional property holder is having, that rights are also given to the IP holders, right? So IP holder can have freedom to acquire, hold, and dispose of the properties like conventional one. The property, that is IP property, can be deprivation of property. It can be protected from the deprivation, as well as the IP property could be purchased or acquired for public purpose only, and law only by law, and only in payment of compensation. It means, like conventional properties, if the property is to be acquired by government or for people's purpose, then that property is acquired some due procedures and with giving the compensation. For example, government needs some land for developing of roads or some city projects or some national projects. Then government acquire the land from the owner, and for that the owner is given some compensation. So same concept is also acquired, is applicable for the IP when if any IP is required, or it is taken by government for people's purpose likewise. Okay, so IP is given exactly same importance like the conventional our properties, right? Now when we say IPRs, so there are different types of IPRs. So one of the IPR in this is patent. So patent gives us patent can be taken for ideas, process, product. Likewise, another type of IPR is about designs, shapes, sizes created. So in picture you can see various types of products are shown. So such products are registered with their design for for prohibiting anyone to copy it, right? So this can be one sort of IPR. In another type of IPR, the trademarks, or sometimes it is called as business marks also. Trademarks is a more common word for them. Trademarks are used to showcase or to differentiate the product from others, or to create the image about the brands in the minds of customers. So trademarks are again registered in conventional way by following the due procedures. So as a part of one IPR. So another type of IPR is copyrights, that we are much more aware about this. The things which are not coming in patents like dramas, music and all that, they are coming under the category of copyright as a part of some text creation or some musical compositions. Then another IPR possibly geographical indications, and which is given for the group of peoples. IPR fifth, that is GI, is never given for individual persons, whereas IPR 1 to 4 are possible to get to individual as well as group, means 2, 3, 4 persons. Likewise, but fifth is not given for a individual person. This is given for that area, geographical area, name itself indicating geographical indications. So district, state, likewise, or some city, sometimes some cities also it is given. So in the picture, if you see Darjeeling tea, Darjeeling tea is the first GI in India which is registered, and that Darjeeling tea is having its uniqueness in terms of its taste, or that taste has been developed due to atmospheric characteristics, characteristics of soils, and that is unique of that area. That's why it has given the GI. Like GI, you can say Rasgulla of West Bengal and Odisha. That was a court issue. So similar type of products can take the GI. Okay. So our today's discussion will be more about invention number IPR number 1, that is patent, right? So one example I'm just taking here. Sometimes we may have multiple IPRs in a single product. Suppose
If you take this as a simple mobile battery, which has multiple IPRs. How this is possible? This we can check. See, Nokia is a brand name of XYZ company, or can but in this uh, name Nokia itself is a trademark, so it's one sort of IPR. Then something is written on the battery in terms of their context, contents about battery or information. So that will be the copyright text. Fact. The battery is so that process or technology will be patented, and the battery is having some unique shape and unique design. So that design is registered under the IPR category. So 4 IPRs we can have in a single product also. This is also possible. Okay. Now coming to how this patenting system came into India, it has started from 1856. In 1856, the British government of that era has taken the British laws of Great Britain as it is to the India. And at that time, the patenting period was 14 years. Later on, in 1870, some improvement has taken place or some modifications has brought by British in the previous law. And then the act was called as the Patent, the Patents and Design Protection Act 1883. And in 1883, the Protection of Invention Act was brought to tackle some of the problems or remove the issues of the 1872 Act. Same change has been brought in 1888, and the act was at that time called as Inventions and Designs Act. Then in 1911, the British brought the specially made Indian Patent Act, which was called as Indian Patents and Design Act, exclusively for India. So till 1888, all the British laws was as it is applicable to India. But in 1911 onwards, the British has developed a special act for India, and in which the patent period was converted from 14 to 16 years. Right? So it was continued till 1970. See this, from 1911 to 1970, the British law, which was known as Indian Patents and Designs Act, was continued, and by that time the period of patent was 16 years. But after independence, government has realized to have the India develop the Patent Act for its own requirement, and the same act came into 1970, and we are using the same one, Indian Patent Act 1970. Of course, subsequent amendments has taken in the law, and that is natural process. Any law, whenever it is in the use or in enforcing condition, the amendments are coming on time to time in that law, and they are called as various types of rules. It is coming, right? So in present 1970 Patent Act, we are having the patent for the period of 20 years. So whatever we are talking about patents, when we are getting any patent in India, that patent is valid for 20 years. Now, more or less, the patent period worldwide is near about same, except some few countries like Australia, somewhere there is some 10 years, but as per WIPO guidelines, it is near about 20 years. Now, in India, we have some litigation for the legislation for controlling the IPR related activities, and accordingly, there is one act of 1970 which is called as Patents Act. For trademark, there is separate act, Trademarks Act 1999, then Designs Act 20,000, the Geographical Indications of Goods Registration and Protection Act 1999, the Copyright Act 1957, amended by the subsequent amendments, and Semiconductor Integrated Circuits Layout Design Act 2000. The Semiconductor Act is specifically taken for the IC and related things where they are not coming under the case of patents. So ICs and motherboards like structures or products what are developed as a unique one, they are not coming for registration under the patent. Instead, they can be registered under the Semiconductor Integrated Circuit Layout Design Act 20,000. This is some laws which are used in India to protect the IPR. Now, as a picture, just try to understand what happens in India. I'm taking this slide because this indicate how much we are ready, or how much we are aware about the IPR systems, and how much Indians are contributing in the IPR part. A report of Government of India by by Department of Science and Technology in 1920 was released. The name of Science and Technology Indicators, SIT. Right. So what that report says? That report says that in India, in the period of 2005-6 to 2019-20, in these 13 years, total 5.1 lakhs patents were filed. Were 6% by foreign companies. And now what say boldly? We say that we are the second largest populous country in the world. But when it comes to like this, we are far behind. So does it mean that we don't know about patenting? We don't have a caliber for the innovations and inventions? Of course we do have, but we don't know much about this IPR part, and simple mistakes we are doing in case of patenting, and we kill the novelty. How we are killing the novelty of our own patents or our own ideas, that will be the discussion of some subsequent slides. But time being, I'm only saying that only 34% patents were filed by Indians in these last 13 years, whereas 76% patents were of foreign companies or foreign persons. This is not a good figure, right? Now, we go again some more details what has happened in different years. So if you say in 2018-19, 50,000 around 51,000 patents were filed, out of which 15,283 were granted the patents, and rest were, you can say, disposed of like this. Okay, so same condition was in 2017-18 when total patents filed were around 48,000. Out of that, only 32.5% were of Indians, and rest of the patents were of foreign companies. Same is applicable for the 2018-19. 33.56% were of India, and rest were other words, right? So this is not a good figure when we are talking about because this is happening because majority of the Indians or we are very less aware about the patenting systems, their importance, and their possible commercialization. So that's why this happens. Now, if you take a very brief idea that how the things are coming in terms of developments and contribution of each state, if you take it's a figure of 2017-18 given it's a patent of 2018 18-19 statistics I have taken from the Control of Patents Office report, in which if you take state wise, so contributions of very few states is only continually leading. Maharashtra, Tamil Nadu, Karnataka, Delhi, Telangana, these are some states which are leading in terms of filing the patent from so many years. Reason is, for others, or can say, if you say all these leading states, they are better than others, but not good, very good compared to international also. Being if you see the populations and number of colleges and number of industries, but awareness needs to get created, right? So more and more people will get aware, more and more people will get information, they will try to file the patents. That number will go increasing. It will increase the mindset of the people to see toward the things, how they can be converted into patents and like this. Okay, so this is something about state-wise. Now, our title of today's discussion is Patenting of Innovations. Intentionally, I have used innovations. When we say innovation, must to us is invention. Invention, of course, when we talk, inventions need to be protected or inventions need to be patented, like these words we see. But what exactly invention means for us? Invention means for us is creating something new, creation of something new, and that becomes the new technology, new knowledge, right? But when we say innovation, then for us, innovation means transformation of an idea or resource into useful applications. Innovations, that is, when we are using innovation, it becomes for us new product, new process, new services, like this. And every innovation, if satisfying the criteria of patentability, can be, let me say, by modifications in the existing system, the product, invention becomes new innovation, or that it becomes a new innovation for small changes or modifications, right? So if there's innovations and inventions have to be understood better, this figure is a self-explanatory. What is invention and what is innovation? Both are patentable. Invention is also patentable and innovation is also patentable. Okay, like this, we can go for patenting the innovations. when we have, right? So when we say that we have to go for innovations or inventions, then usually we believe that we should have very creative mind to have the patents and to have the research, I mean that to find something new for the patents. So but experts say it's not like that. We need not to have every time, we need not to have only innovative mind, but we need curious mind, right? So these are the persons in India. This is one of the I mean this picture I have taken from last June paper of Times of India, and in this it is mentioned these are the leading stakeholders. These yellow number patents they have filed, or these are the patents on their name, not filed, they are the granted actually, right? So 22270 all these are the patents registered with their name. Then what they say for this, I have just taken for your sake of understanding what this fellow says about the patenting systems. He is Mr. Sandeep Patil, and he is a IBM storage chief technical officer working in an IBM company. And what he say, I'm using as it is his words so that we can understand better way. He say that I want to break the myth that inventions are only for those sitting in closed door labs, that you need a I can, this is important, I can your IQ. Anyone can become an inventor. Innovations is not a God-given talent. You should just be passionate about it. One should be passionate, right? So this is something what the experts say about the patenting systems, right? This is not only me. When we say we want innovations, then some ideas how they are coming. You are taken by referring that you can also see that how the ideas are coming and how they can be developed. See these simple products. This is paperclip, one of the very commonly used stationary item in our day-to-day office work. But very first time in US in 1927, it was a patented product. Patent was given for this product to the inventor. See how simple this is. But at very first time, it was brought and it was patented. Then, but very beginning, it was about combining the eraser with the pencil. Bath soap case, patented product. When it was first launched, this case at very low cost. It was the US patent. Then, how idea develops? For that, just see this picture. See this, ask yourself, what's more about these shoes? What these shoes can do? What more we are expecting from the shoes? Try to ask yourself for a few seconds, what more will these shoes, for which we can think for patent also. In a normal view, when we try to see this, we see that, no, nothing new, it's simple one. Like a conventional shoe, this is one of the shoes, and what we can do this. But how the small change in thinking also makes difference, this you can try to understand. For that, one school student, Miss Datta, who is from Jalandhar, Punjab, and in 2011, she was in the 9th class. She thought about these shoes very differently, and for her different thinking, National Innovation Foundation of Government of India had chosen her thinking, has awarded her with the Ignite Awards in 2011, and later the National Innovation Foundation filed patent of her with a concept. She has developed shoes. Just imagine, develop shoes to calculate time spent in a physical activity. Right now, how we are measuring the time spent in physical activity? Usually we are using some sort of gadgets, right? Mobile or something we keep, and then you try to measure how much steps I have walked, how much distance I have run, how much hours I have done swimming, how much hours I have done exercise, like all this, how much calories I have burned. But just imagine, if your shoes itself is able to give all this information, then why we should have any gadget? Just over the shoes and walk. What you want to do? That shoes will give idea how much calories you have burned, how much distance you have traveled. And this simple concept was proposed by the this Miss Datta, and later one of the patent has been filed the National Innovation Foundation. Like a small change in thinking only, right? One more example about this shoes. Same. See this one picture. He's a very famous dancer, MJ, Michael Jackson. And see the bend while dancing. He has bent around 45 degree, inclined 45 degree. I tell you, normal person cannot bend 45 degree and then dance. To confirm my statement, to do some activity, talking or write something, any activity. But at that time, Michael Jackson and he was really dancing at 45 degree, and those who were not aware about this, people used to this team is really God gifted. So it was not a God gifted talent something. It was a which the Michael Jackson was taken as patent. It is same maybe, but that patent is on the name of Michael Jackson. Has developed one shoes which is called as anti-gravity lean. Anti-gravity lean, and by using that we can bend or we can buckle like this in a 45 degree for dance or and bend at most 20 degree and then do dance or what is required. But at that bend at the 45 degree. So this is also something different from the same shoes what you are from the otherwise differently. See this picture, staple pins and stapler. So what is possible invention in this or innovation in this? This question was obvious to one school girl. She is Miss Ankita from Pune, and she was also awarded Ignite Awards by National Innovation Foundation 2011 for her invention, and after that innovation went into a patent, right? So her concept was to color the pins of any other end from this or this side. 4 to 5 pins has to colored by some permanent marker or like this. And whenever the step process will continue or pin process will continue, colored pin will to come out on the paper. It is an indication that pins the stapler are likely to over, and we have to put the new pins. Otherwise, in conventionally, what is happening? We are just going on stapling, and when last pin comes, our stapler goes empty, and we feel that array pins are over. Then we start to searching the pins, and sometimes we may find or we may not. So to avoid this last moment finding, she has proposed this idea, and her idea is patented or file a patent by National Innovation Foundation in 2011. Okay, simple idea but patentable. Fine. Now, one more simple idea I'm taking, how people are thinking different. This is one notebook, and that notebook is given name for mathematics notebook. It's a US patent of this number, and it is recently filed, not very old, in 2007. So what you can understand from this new notebook, and literally again let me do, this patent I have personally checked, and this is the only 7 pages patent, including diagrams, abstract. What inventor has proposed? Inventor has proposed a notebook with vertical lines. Conventionally, we are having the notebook of horizontal lines, and he has proposed a notebook of vertical lines for doing the mathematical calculations. And he proved or he proposed that by using this type of notebook, vertical lines, the chances of getting mistakes in the mathematics calculation is nullified, and this approach is taken as a patent. Very simple idea. What is simple? Notebook with vertical lines and patent. Same is possible with one more idea like this. This is one notebook where a pocket is given or a flap is given to keep the pen. Conventionally, what we are doing when we want to put a pen for writing in notebook, we try to put the pen in the notebook and we try to hold it. Whenever we don't have any pocket, when we don't have purse, is for which one he has attached pocket, and it has become pen holder. And this book with pen holder was given a patent in China with this number. Okay. Similar concept, that is pen holder with notebook is also taken the patent in Japan. So these two examples I have taken intentionally same. Reason is, see, if you see the objective of both inventions, they are same. Pen holder to notebook. Here also, pen holder to notebook, pen holder to notebook. My point to say is, though idea is simple and all that, but I want to give one more point. Sometimes we feel that XYZ is already filed in that patent in that area, so I cannot do this. So it's a myth. Then what is reality? Reality is that a patent can be filed for multiple ideas for the same objective. Here objective is to have the notebook with pen holder. So two different inventors have tried and both have got the patent. So this is possible, right? So like this simple idea, we can have different thinkings and we can go for the patenting. Then my question comes, when we have all these ideas, why we need to go for patent? A patent gives us chances to rent it. We can rent if we have patent. We can sell it if we want to that. Even in worldwide also, there are many companies which are working in the area of inventions and innovations, and they don't have their manufacturing facilities. Then what they do, whatever inventions they are coming, they develop the inventions, they get it patent or protected, and then they sell it. And by that, they are generating the revenue. Then, once we have patent, we can stop others from using it without our permission. This is possible. And we can use it for our purpose, for business or residence if it is required, or if we have our own abilities, we can go for the using that patent for our purpose. Then when we say all these are the issues, all these are the contents of various patents, then patent for us means exactly what? Then it's a set of exclusive rights. Patent is a set of exclusive rights granted by a government or sovereign government to an inventor or his assignee for a limited period of time. Against what? Against a detailed public disclosure of the invention. This is, remember, patent is only granted if the invention is truly disclosed in all the aspects to the public. If you are trying to get the patent with partially disclosing the inventions, then it will get rejected during the examination stage. So whenever we want to go for patent, we have to disclose the inventions in a very detailed way. When we get the patent, then the patent owner has got the get the exclusive rights, and that rights makes that rights excludes others. That right excludes others from what? Making the invention, that is same what we have, then using it, selling it, and offering the invention, and finally importing. If we have, just I was talking in the beginning, if we have any one patent with our name or with our firm or with our company, you can say, and that patent is being infringed in some other countries, but we know that patents are given for the specific jurisdiction for the specific time. So suppose any country, say example the China, is trying to copy some patent ideas, then they can sell that product in their country, possible. But if they are trying to sell the product to India in which that invention is protected, then such importing will be possible to stop by the inventor. So importing the invention is possible to stop. Now we'll try to understand, when we are discussing about the different types of patents, let us briefly discuss what are the different types of patents which are not patentable, that is inventions which are not patentable. Briefly coming on this, the inventions which are frivolous and misleading, the inventions which are frivolous and misleading, or which claims anything against the well established laws or natural laws, then it is not possible to get the patent. For example, if we are talking about how we have developed a machine and we are saying that our machine is working without input, it is giving output but it is not taking any input, so this is not possible, this is a frivolous, so such machines is not patentable. Similarly, a machine providing law of gravitation to be false is not patentable, as law of gravitation is well established against natural law, right? It means which is coming against the natural, well established natural laws, such inventions cannot be taken as a patent. Then inventions contrary to the public order or morality, or which causes serious danger to human, animal, or plant life or health to the environment are not patentable. Contrary to the public health or public morality means what? Suppose one machine has been developed which is used to commit the suicide. See this. One inventor has developed a machine which is helping to commit the suicide. So this is what? This is against the morality. This is against the public order. So this won't be the patentable inventions. Likewise, invention to enhance environmental pollutions. That such invention is also not possible to get patent. And finally, in this category, one more example you can try to say that the application that helps to hack the emails of others, or email hacking software is supposed developed. So such softwares or such inventions will not be patentable. Okay. Then continuing in the same topic, mere discovery of a systematic scientific principle or abstract theory is not possible to register. Means what? Newton's law or theory of relativity are scientific principles and hence are not patentable. Condition is, however, if you develop some principles in terms of application or product on these theories, then that theories will be patentable. That product will be patentable. So, in which finding the new type of microorganism occurring freely in the nature is discovery and not an invention. So therefore cannot be patentable, but application of it is patentable. It means microorganism, suppose you are finding, it is not patentable, but by using the different microorganisms and some biotechnology based medicine or some formulas developed for treating some disease of plants or animals, like, so that is possible to patent. So it's applicable possible. Now, mere discovery of new form of known substances is not patentable. Like that, we know the use of neems. So somebody saying that neem is useful in very different way, like that. So it is not patentable. Sometimes the use of these discovery elements, if they are combined in a synergistic way, for example, soap, detergent, lubricants, polymers, etc., they can be patentable because only neem we know. But if we are using neem with other some elements and then we are forming a synergistic composition, that composition will be patentable. Substances obtained by mere admixture are not patentable. For example, if you are adding the sugar with the water, so that will give the more sweetness. So this is a just admixture. We cannot go for patenting this, right? So arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way, are also not patentable. Example I have taken, by that you can understand what I mean to say. If we have an umbrella and a fan, normally we know that umbrella we are using to protect ourselves from sun or monsoon. In sun, when we are protecting ourselves from sun, umbrella is used to protect ourselves from sun, then we feel something like sweating. So to avoid that, or to give the more comfort, suppose somebody is fitting one small fan on umbrella, and then it will become umbrella with fan, and then we'll say that I want to go for patenting. So in that case, umbrella is separate, fan is separate. They are working independently, and just a combination. So it's not an innovation. Same way, if we fit a chair with umbrella for sitting, it won't be the innovation. And in earlier days, transistors and cassette players were there in a combined form, so which was not also the innovation. Then non-patentable inventions, what we are having, they can be the method of agriculture or horticulture. We cannot go for patenting them. Similarly, the process of medicine, curative or treatment of human being or animals is also not patentable. For example, a method of surgery, method of treatment of teeth, etc., is found by the doctor. Any new way for doing the same one is not also patentable. Plants, animals, as well as seeds, varieties, and species are not patentable. But again, let me tell you, but plants and animals are protection with a different law in India, and that is called as Protection of Plant Varieties and Farmers Act 2002, and by that we are getting the protection for seeds and varieties and other species. Okay, so that is a separate or unique protection provided by the law. Then microorganisms are patentable provided they fulfill the criteria of patentability, that is novelty, industrial applications, or non-obviousness. Then one more non-invention possible is in mathematical or business models, whatever we have developed, or computer programs, they cannot be directly patentable. However, about computer programs, if a computer program is to be patentable, then computer programs need to combine with some sort of hardware, right? Then we can do this. For example, we have developed some application for door opening, only software. So only software won't work. But if you are combining the software with some hardware and then developing the device to open the door automatic, which is a computer control, then that will be the innovation patentable possible. Same is mathematical models or business models. Mathematical models, whatever we are developing, they are not patentable. Same is applicable about business model, not patentable. Then, same I have mentioned, literary, dramatic, musical, artistic works are not patentable. However, they are, that is cinematography, drama, music, literacy, these can be protected under the separate category called as IPR. So they can be protected under IPR and not under the patent. And some few last before closing, some inventions. Mere scheme or rule of method of performing mental arts or method of playing game is not patentable. Just teaching methods like this, not patentable. Method of presentation of information, not patentable. Topography of integrated circuits, not patentable. In the introduction parts I mentioned, semiconductor theory related inventions are protected by the different law, not by the patent. Traditional knowledge or aggregation of known properties is not patentable, but like health benefits of turmeric, etc., we cannot go for the patent. And lastly, the inventions which are coming about atomic energy are not patentable. This is the one which is coming in clause 4, and all the above 1 to 13 are in clause 3 about the non-patentability inventions. Okay, this is brief. I have taken somewhat speedily because my just idea was to make you aware what areas not patentable. Because if an inventor is new, then he or she may not be aware that whether my area is patentable or not, and in that she may or he may think that I want to go for patents and like this, and then later stage it may get rejected, right? So recently one person approached me for patents, and he was interested to file some patent about his PhD research work in which he has developed some mathematical model. So he approached me, I listened everything about him, and then finally told that, sir, this is a mathematical model only, not any device working on the principles of that model. So only formula, only mathematical model, we cannot go for patent. If you want to do so, then we have to go for developing some device in which we can use, that device can be used on the controlling of mathematical based equations, but hardware is required. So it means inventions we must know which are not patentable, right? So coming to the next important aspect, whenever we say that we want to patent any our inventions, that invention should satisfy 3 criteria. Inventions must be novel, it must be non-obvious, and it must be of industrial use. Then only that inventions can be patentable. What it exactly means, that let us try to understand. When we say that novel means it must distinguish it from the state of art, usually called as prior art. Means what? For the same thing, what is existing condition and how the new development is previous. So this will give you the idea of state of the art. Right? It means it should be non-obvious to the persons which are skilled in that. It is, I'm just elaborating on what it means. When we say persons skilled in the art, means the persons which are working in that art from so many days, their expertise. For example, if you take driver, when the driver is expert in the driving vehicles, so he will be called as a person skilled in the art. Carpenter, person skilled in the art. Mechanic, person skilled in the art, right? So for such persons, whatever proposing, it should be non-obvious. They should also say that, oh, this is new, I don't know this. Likewise, so it should have the inventive step. And third condition, that it should have the industrial application. A patent is only granted for the products which are possible to produce or to sell in the industries or to develop in the industries. And finally, the inventions which are coming under the category of 3 and under the category of 4, just what we discussed previously. Section 3 means non-patentable inventions, and section 4 means inventions under coming the atomic energy. They are not patentable. Okay, so novelty, inventive state, and industrial applicability must be there to have the patent. Okay, so what novelty means, shortly I'm coming. This novelty means it's a key, it's a heart of the patent, and invention should not be anticipated by any previous publication, any previous claims, or public use or public knowledge. What it means, novelty means, now being in academic fraternity or teaching faculty, many times we develop something new product, small project, but we're very hurry about to publish it in terms of conference, in terms of some journal. If not, we try to put it to our social media to try to show, means we're trying to make that innovative product to the public domain, which is against the principles of IPR. So unless and until you are filing the patent about that inventions or innovations, don't disclose it to the public. So it should not be anticipated, it should not be shown to the public what you are developing or what you are doing, unless and until at least you are filing the paper. Sorry, unless and until you are at least filing the provisional patents on that. Okay. So anything that is readily available to the public is called as disclosure. People know it is public disclosure. So our invention should not be publicly disclosed before filing the patent. And like a journal paper, a conference presentation, a publication on web, Facebook, YouTube video, public news group or blog, talking with external parties about the invention with the use of confidential agreement, all these are the locations where you can go for anticipation. Anticipation means public knows about your invention. So in simple, if you want to protect the novelty of the product or development, then don't disclose it to the anyone except you. Once you are filing the patent, then you can talk with anyone, or if it goes to public, then it won't issue. Like inventive step means it should be non-obvious. The technical advancement as compared to the existing knowledge should be there. Means what is happening in that domain presently, it should be, your invention should be more than that. It should be technically advanced. And this or this, economic significance or both. It should have technical advancement with economic significance. It can be of same type, but it can be of very reduced cost. Economic significance, then also possible to have the inventive step. Invention is not obvious to a person skilled in the art. This should be skilled. Obvious, or if a skilled person feels that it is obvious, yes, I know this, yes, I can easily do this. If this is case, then it is not having the inventive step. To understand the woods, right? But before, when this machine was coming very first time, at that time people were known about this only frame for cutting. But when it has came into market, it has, though it was having some higher cost, but changed. And the persons who were using this type of devices, they also feel that, oh, it's new, it's very good. It means persons skilled the art have also appreciated the inventions, and which has become later the patented product, right? So inventive step means non-obvious variations from what is publicly known. One more example of inventive step. Inventive step one pen, but in the previous pencil, the conventional typical would look mechanism provided, and it gives more effective way for writing or drawing the things. Okay? Same way, we can go for industrial application also. The invention should be capable for industry, to produce in industry or to use in the industry. It must be capable of being applied in an industry, which means that the invention must have practical application. Is that every innovation may have some patentability scope, is expected to get the converted into patents. So when we say that inventions, the patent experts check the invention and called as priority art. So journals, books, patents, illustrations, governments, documents, all that or not. Now, in previous discussion, we have said that the invention should be novel, it should be non-obvious, and it should be industrial application. But in news, somewhere last year, somewhere, one news was there in media that Satyamev Jayate is taken as a patent by Amir Khan. Satyamev Jayate slogan is taken by Amir Khan as a part of his patent. But this was a misleading news. It was not a true news. Because why? By using only Satyamev Jayate, it is violating the things of what? Non-obviousness. It is not non-obvious because Satyamev Jayate is a sentence which is known to the Indians from so many years. Even this is a government slogan, Central Government of India. It's a slogan, Satyamev Jayate. So it was in public domain from so many years. So it was not possible. But maybe someone guided American to file the patent. He has filed the patent, and later on, so many issues, court matters, and all it has happened about the American's patent. So my point is that when your invention is not obvious, or it is obvious, then we cannot say that it is a patentable. It should be non-obvious, novel, and industrial applicability. Okay. Once you understood that how the patent is it's possible to get, you can say, file search for patentability or what criteria we are having for the patentability. Let us try to understand briefly how the patent procedure works in India. When patent is to be filed either in complete or provisional form. Complete form filing or provisional filing is possible, and this complete or provisional filing goes through as a part of first step. After filing, next step comes of publication. If we have filed the complete specification of the patent, then after 18 months it will get automatically published, and it will remain in the public domain for some certain months. 5-6 months it will remain there in published condition, so that if anyone wants to know about your patent, he or she can search it, and if they are interested to give its oppose, then they can file a pre-grant opposition and the procedure will continue. If no pre-grant opposition is there, then it will go to examination. That is, after publication, next step will be examination. So this is step number 3. First filing, publication, and examination. In the examination, the patent examiners examine your application very critically. They try to find out various types of similarities between your patent and other patents, as well as claims, and they try to say that one first examination some documental proof or response, filing response to the PR. Once that response is taken as positively by the patent office, then patent is given the granting and process continue. If the response is not taken as a positive and it needs some further clarification, then further examination may be possible. After hearing also, if the examiner is not satisfied, then patent will be refused. Right? So usually, hold this process to be completed within 1 month. Okay. And after that, if everything is smooth, then patent is granted by the notification. It is notified to the general public that Mr. XYZ is being granted the patent on this issue. If anyone is having objection, they can raise. So from the grant date of the patent to the 1 year after patent, anyone can file the opposition, which is called as post grant opposition, will happen within 1 year. And this grant opposition may refused or may grant, and if it is refused, then we may get the nil. It means after post grant, it is patent is refused, then it will be reverted, and if the opposition is waived off or opposition is satisfied, then patent is granted. So like this, the patent procedure works. So starting from first, if you say around 2 to 3 years time goes in total filing of the patents. So this way, sometimes for they try for early publication. So there is one provision in the Patents Act. By filing the form number 9, we can go for early publication, and for that we have to pay extra fee. Paying extra fee, the patent can be can published early than the 18 months. And then it continues the cycles of procedures, hearing, decision, and like this. Okay. So hope this is a normal procedure. You understood how this is happening. So while filing, I was mentioning we can have the complete filing and provisional filing. But before that, in short, I'm just mentioning in India, the patenting procedures has changed drastically after 2005. Before 2005, there was no provision for the publication. Filing the patent application direct examination. Exam given Mr. XYZ is going to get the patent. If anyone is having an objection, they can raise. But now, as it is getting published after filing, so public is come to know about every details of the inventions. And if anyone wants to raise any objection, possible. After that, it can be examination and subsequent steps are same after 2005 also. Okay, so when you go for actually filing the documents, then what we need to do actually, this I'm taking for manual filing. We have to go for filing the form number 1 in duplicate copy, same like filing the form number 2, which is the specification, might be complete or provisional. Then statement of undertaking in form number 3, mentioning that the inventor has not filed any patent in India, sorry, outside India before this on the same inventions, or later also if any patent is filed, then inventor will keep updating the controller of patents about the same invention. So this declaration we are giving in the form number 3. In form number 5, we declare that I am the true and first inventor of this invention, and all things related to it. If you have hired someone else to file the things on behalf of you, in that case, the power of pattern in form number 26 to be given, and certified true copy of the priority document. If it is filed provisional, then it is required. Okay. And with this, most important is fees of the patent office. Specified check is to be given. In next slide, we have some fees also. So provisional specification, I'm quickly coming. Sometimes what happens, invention time is like 2 but only 5 minutes. Time is short for us. Some invention is not complete. It is in the stage of development. For example, nowadays we are taking the corona vaccine. The corona vaccine started development near about last year, 1 year back. When it has started in the development, the inventors might have filed patent at that time only, provisional specification. And during the course of development, they have developed the things, and within 1 year after filing the provisional, they might have filed the complete. So provisional specification give to take the date of priority or date in advance about the inventions, and we can give the more details within 12 months from the provisional specification. Within 12 months, it is expected that the invention will get completed and it will be updated. Okay. So for filing this, filing charges of 1750 for 30 pages invention, and after that, after 30, each page is taken as a 180 rupees. These are the charges. Provisional specification is only taken for the benefit of priority dates. Within 1 year, just I mentioned, within 1 year of provisional specification, we have to find the complete. Then provisional specifications are not rough draft and cannot be changed. These are the details shortly. I want to come on complete. So when we are filing the complete specification, the complete specification of a patent will have these contents. It will have title of the invention, preamble of the invention, field of the invention, background of invention, objects of invention, brief description of figures if they are, statement of invention, detailed description of invention, claims, abstract. While forming these, there are only 2 limitations. Title must be of 15 words and abstract should be of 150 words. Then we can file the patent. Okay. So one suggestive word is that if your invention is ready, in terms of engineering colleges or professional institutes, inventions means many times we are taking UG projects, BE projects, there can be complete. If they are ready, they can be filed directly complete. Then publication, just I mentioned after 18 months it is getting published and early publication possible. And early publication by paying rupees fee of rupees 2500. We can go for the early publication. Now, early publication after reaching application to the patent office will take into effect within 1 month, and it will come to the public domain. Last point of technical discussion. After publication, it will be examination, and from filing of the examination, from filing the provisional application or complete application, within 48 months, we have to apply patent cannot be granted. It won't be taken for the examination. So examination request is mandatory, and controller of examiners can decide the APR reports or details of that. And again, let me tell you, the statement of objections which in through APR, it should be replied within the 6 months. So if application is made by the startups or small scale companies, then there is a provision in latest amendments by going for the expedited examinations. So need not to wait for the patent. Then first inventor, a person, and legal representatives. These persons can file the patent in India. When we have to file the patents, we can file the patents in 4 cities in India: Chennai, Mumbai, New Delhi, and Kolkata. These are the 4 metros, and they are leading their geographical locations for filing the patent, right? So West India is coming state Maharashtra, Gujarat, Madhya Pradesh, Goa, all they are attached to this. Same is for Chennai, Mumbai, and Kolkata. While filing the patent, we should note how much fees is required. If you are manual filing, then filing requires 1750, publication 2750. If it is publication, if then 4400 is mandatory. If the applicant is an organization like company or college, then fees are different. Okay, so like this way, filing can be. And when we are going for submitting patent application, it can be online, it can be by post. We can do this any of the way, right? When we are getting the patent, just I mentioned to right, agreement, royalty, and these are some limitations also, right? So professional theory finally, before closing, patent before publicly disclosing important research results that may lead to valuable product to technology. It means if you are publishing, then it will lose its novelty. It will become known to the public, right? It will become obvious. Then first we have to find the patent in that case, and then we can go for publication. And in there, we can use some details like drawings, preparation, various forms, submitting the application to the patent office. And finally, it is suggested that if the novelty is to be kept at very high level, then expert services are always advised to hire. Because if you are filing the patent by your own, not able to succeed in all technical discussions, you are filing it, you are publishing it, it means it is getting public. And if it is not getting granted at the examination stage, then your invention will go in waste, your efforts will go in waste, and your invention will become public. Later on, you cannot do this. So wherever possible, take the help of experts in that area. So they will help you to get the patents go through. Okay. So I'm finally, for engineering institutes, we have very wide scope. UG, PG, PhD, dissertations or projects can be potential for the patent if they are searched in a professional way, and around 5 to 10 projects can be taken for filing the projects in terms of UG, PG or PhD projects. Okay, so this is from my side. I was having limitations given for 1 hour, so some things I have taken somewhat speed up. But if you have any doubt from your side, you can ask, please.
Thank you so much, sir, for this wonderful session. You have shared so much fruitful information with us. So I hope it will helpful to all the students in future. Okay, sir, you have basically covered almost all the things in step by step. That's why there are no question session from the audience side.
Okay.
Okay, sir. So thank you so much, sir. Again, you have given your valuable time and sharing your valuable information with us on a very short notice.
Okay, ma'am. Thank you.
So,
Thank
sir,
you.
I appreciate your presence on behalf of whole Parallel University. And thanks to Parallel University webinar cell for
Okay,
constant
ma'am.
support. And in last to Parallel University for giving me an opportunity for being hosted such a kind of webinar. Thanks once again for joining us. So we'll see you next you again. Thank you so much, sir.
Okay, ma'am. Thank you.